Uh, Today, I am very privileged to be an anchor for the 50th IPNet webinar on a knowledge session on creditor-initiated insolvency resolution process. This is proposed framework under the IBC Amendment Bill 2025. Good evening and a very warm welcome to one and all. On behalf of IPNet West Region, I would like to extend a warm welcome to all of you on today's webinar titled Creditor Initiated Insolvency Resolution Process. We are truly honored to have our distinguished keynote address by Dr. Ashish Makhija sir and our lead speaker, Mr. Udayaraj Patwardhan sir, along with moderator and speaker, Ms. Namrata Randeri. As you are all aware, IPNet is hosting its 50th webinar in a series of webinars organized periodically under the umbrella of IPNet, the National Network for Insolvency Professionals. Now, without a further ado, it is my pleasure to invite Mr. Udayaraj Patwardhan sir, member of National Executive Committee and Regional Head of IPNet West, to deliver the formal welcome address. Sir, the stage is all yours. Patwardhan.
That is the number that we have reached 50th webinar. So we have come a long way, and I've been fortunate to be there since the first webinar itself. Yeah. So we are today having our 50th webinar, and that topic is a very unique one. Thank you. So this is the topic, creditor-initiated insolvency resolution process, which is proposed under the new amendment, Bill 2025. This is a very interesting new framework. And as we are all aware, IPNet and IIIPA of ICAI, led by Dr. Ashish Makhija and assisted by me, we had two back-to-back consecutive sessions on the amendment bill. However, due to paucity of time, we couldn't do detailed ones of CIRP or cross-border or group insolvency. So we will be taking up these subjects one by one. And while we are doing that, I would just again remind us all that we as an IPNet have thrived over last 51 years. We are completing our 1 year as well. So we have been able to hold a lot of webinars. We have multiple study groups and they are led by experts. We also provide practical guidance on IBC related challenges, and we have a dedicated member portal also. So with this, let us proceed today and celebrate our 50th webinar as well as our 1 year birthday. And I will hand it back over to Gauri for the further proceedings.
Gauri, you're on mute.
Take it forward.
Yes, sir. And I'll also share the video, sir, of our IP.
Please go ahead.
Which gives us the entire backdrop of IPNet. I will just share the combined video.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Smarter and more connected community of insolvency professionals. Together, we can the profession and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Gauri, please unmute yourself.
Yes. May I now move forward? And I would like to introduce our keynote speaker and our president of IPNet, Shri Ashish Makhija sir. And he, as we all know, but I would still like to uh, introduce him. And he is Supreme Court, High Court, NCLAT, and NCLT advocate. And apart from that, he holds a PhD in law from Emory Law School in the USA. He is a dual LLM. He is a fellow chartered accountant, and he is adjacent faculty at Indian Institute of Corporate Affairs. And he has authored many books, including Insolvency and Bankruptcy Code of India. Apart from this, what I would like to give my perception is that he is a very good speaker. And apart from the very good speaker, he is always inclined to solve many difficulties of all the IP members. And at times, I would say some of my dumbest queries also he has answered in a very humble way. So I would like to, I would like to welcome Makhija sir with this. Makhija sir.
Yeah, thank you. Thank you, Gauriji, for your kind words. Friends, first of all, a very good evening, good afternoon to everyone. Well, it gives me an absolutely immense joy to be here today as we celebrate 1 full year of IPNet and the milestone of our 50th webinar today. Now, what started as a small platform for sharing knowledge has now grown into a vibrant community of insolvency professionals, academicians, lawyers, and even students who are coming together week after week to learn, debate, and exchange ideas. Over the past years, friends, we have explored many of the most complex and evolving issues under the Insolvency and Bankruptcy Code. We have done programs which are relating to the problems and issues. We have made a lot of representations to the authorities, and I'm so happy that many of them have resulted in changed regulations and also the insolvency and bankruptcy bill, which is already pending before the parliament. From landmark judgments to practical challenges, from new legislative amendments to international practices, I think IPNet has created a space where learning never stops. Friends, reaching 50 webinars is no small feat, week after week. That's 50 weekends of commitment, preparation, and of course, enthusiasm. Now, as the saying goes, consistency is what transforms average into excellence. And IPNet has shown exactly that consistency, quality, and of course, inclusiveness. I want to take a moment, my dear friends, to thank every speaker, every participant, and the entire IPNet team who made this journey possible. Together, we have built more than just a knowledge sharing forum. We have built a network. We have built a family. We have built a movement that keeps insolvency practice dynamic as well as informed. Here is to many more anniversaries, many more webinars, and many more moments of learning together. Well, congratulations to everyone who has been a part of this journey. And let's raise a virtual toast to the next 50. So, friends, I'm absolutely delighted to be a part of it in the 50th webinar also. Now, coming to the topic of today, and I think we have got fantastic speaker. Now, this is one thing which has developed over a period of time. Friends, can I request everyone to please open your videos if it is possible? I think it's always better to have better interaction and see smiling faces. Yeah, thank you so much. So what happens, friends, with this IP net, in fact, I would also encourage each one of you that if you would like to take some sessions, become a faculty, reach out to us, reach out to the regional heads. I think we are always open and we have created a lot of speakers. And the best example is even Namrata today coming as a speaker. So I think I'm so delighted to see all these people that we have created faculties and speakers out of the people who are not willing to come forward, or rather they never had the confidence to come forward. So I think this is something which we are very, very proud of. And this has given us a great cohesiveness also. So today, you see, learned speakers are there. Mr. Patwardhan, I think we have done 2 programs on insolvency and bankruptcy bill. But today we are coming out with a specific topic, which is creditor-initiated insolvency resolution process. So I'm not going to speak too much on that. I'll just give a few issues which are the concerns which I believe are there, and I think they need to be sorted out before the final version of creditor insolvency resolution process takes shape. So let me walk you through in very briefly what are the issues, key issues which could be highlighted. Friends, if we look at the scheme of the things, which is CIIRP, we call it as now CIIRP, it is complicated, it is not simplified. It has been designed as an alternative to corporate insolvency resolution process, but this process is anything but simple, if you take my words. Now, from the very beginning, it requires a majority creditor approval of 51%, which might be difficult at many times, a formal notice period to the debtor. Then there is a space for debtor's objection. Corporate debtor can file its objections, and those objections will be dealt by the adjudicating authority so therefore the adjudicating authority will have to deal with those things. Now, each of these steps now creates additional procedural hurdles and scope for disputes. Now, assuming the NCLT or tribunal does not hold it in favor of the corporate debtor, naturally they are going to file an appeal. And again, the second appeal may go up to Supreme Court. So are we not creating another style of litigation or scope for many more disputes? So far from streamlining the initiation, it may actually add another layer of complexity. So this is one concern which I typically have in this. Second, tribunal delays, I think all of us are understanding that undermine the timelines. CIIRP is built on a strict 150-day timeline with one time extension of 45 days. But let's be realistic, friends. Are the NCLTs not overburdened? And timelines under CIRP have also been consistently missed. And recently, IPNet circulated a question which was raised in a parliament. Do you know how many days which have been mentioned? On an average, 497 days on an average for a CIRP. Now, expecting the tribunal to decide objections within 30 days or conclude the CIRP within 150 days seems to be absolutely unrealistic, my dear friends. So without structural fixes to the tribunal capacity or maybe some other improvements, the processes which are proposed may run into delays. Well, it is trying to solve that delay, but I believe it will be a part of the problem there. The third concern is the moratorium issue. Unlike CIRP, where moratorium becomes automatic, in CIIRP, it is optional and subject to tribunal discretion. Now, I was wondering on what basis the tribunal will decide whether the moratorium is required or not required. I mean, I was really surprised to read these kind of provisions. So honestly, can you think of any insolvency case where moratorium is not needed? Without it, the creditors will continue parallel actions. It will frustrate the resolution process. So making moratorium discretionary, it typically undermines the very idea of insolvency as a collective proceeding. So I think there is one issue, great issue, which is to be dealt with. Of course, I believe Mr. Patwardhan will take you to those minute details also. Then there is another concern relating to duplication of efforts. Now, this is a very big concern. CIRP will run for either 150 days or with extension 195 days. And if no resolution plan is approved, it gets converted into a full CIRP. Now, there comes a doubt. Does CIRP start from zero or from what stage? Does the debtor, now the corporate debtor or whatever the RP, will he get full 180 days? Or some period will be deducted out of it, or the time consumed in CIRP will be deducted. The law is absolutely silent on this, Prince. Now, this ambiguity could mean that this is a process, and after that, CIRP can also go on. So instead of 527 days or 497 days, we would be looking at 700 days now. So wasted months, repeated claim submissions, litigation over timelines. I think this is something which the government really needs to look at it. The another aspect which is very important is I would like to address that is risk of collusion and manipulation. Now, according to me, because here the promoters retain the control, the management retains the control. So CIRP, according to me, there are chances that it may open the door to potential manipulation. Now imagine a CIRP application pending for months because the debtor, corporate debtor is contesting it. Suddenly, the debtor can strike a deal with the majority of the financial creditor and they initiate the CIRP, frustrating the CIRP. Well, friends, the risk is not simply theoretical. The similar deals, I don't know, they may also be happening in CIRP. We are seeing that in of late. Let's be very open and honest about it. Now, especially in cases led by some types of companies. Now, unless safeguards are built in, friends, CIRP could worsen these practices. Now, this is something which again needs to be looked at it. And then majority capture and minority rights. Now, this is also very important. The initiation depends upon 51% of the financial creditor. So this means a dominant lender possibly working with the promoters can steer the process in their favor. So what happens to 49% of the creditors? They could be sidelined. So unless the law excludes the related parties from the count or requires a higher threshold, I think this will compromise entirely. The fairness will be compromised. And then transparency, then of course the CIRP is typically designed as out of court initiation. So, but it risks being seen as no confidence motion against the adjudicating authority. So, where adjudicating authority has no role in initiation. It will only be hearing the objections. That's all. So, market can bypass the tribunal. But judicial oversight is central to IBC, my dear friend. So, it keeps insolvency from being misused. Otherwise, what was the need of IBC then? Then the SARFAESI was also there where the takeover of the management could be could take place. So I think what my suggestion is, of course, I think this could be debated by Mr. Bhatt and Namrata ji also, Mr. Udayraj Bhatt. So Udayraj Patwardhan ji, sorry. So this is what I want to suggest is that if you want to give a control to the debtor possession is the goal, can't we achieve it in CIRP itself by adding safeguards? So we can have two track of CIRPs. In one track, where the debtor stays in possession under the supervision of the RP, and the second track could be the creditors take control, immediately in case there is a manipulation or there are chances of fraud or non-cooperation. There are certain cases, so we can do that. So I think the existing jurisprudence can be built on this because in CIRP we have seen many things have settled down. Now you are bringing few more sections where the interpretation of those sections will ultimately go to Supreme Court. Don't you think it will again become an evolving law rather than becoming the evolved law. So I think in conclusion, I can say, sir, friends, the CIRP is well intentioned, no doubt about it, but it risks adding complexity. It could be a duplication of effort, and there is a chances of abuse without solving the fundamental problems of the tribunal delays and of course the creditor coordination. So instead of building an entirely new process, I think it is much wiser to refine the existing CIRP, create a debtor in possession track. So we can have two tracks in the CIRP itself, and then strengthen the oversight mechanism. So the focus, according to me, friends, should be on clarity, consistency, and capacity. Three C's are very important here, not on multiplying the processes that may create fresh, interpretive uncertainty going to the courts. So thank you, my dear friends. I just wanted to mention these issues and the concerns, and of course, in detail, the procedural parts and other things, I think Mr. Patwardhan and Namrata ji will carry forward from here itself. Thank you so much, friends, for being a part of IPNet and making it absolutely on the top of, because it's your community. So it's your community, it's your own family. Thank you so much. Thank you.
Thank you, sir.
Thank you, sir. Yes,
May
God.
I take it forward?
Yes.
Yes. Now we will move ahead with the introduction of our speaker for the today's webinar, Mr. Udayraj Patwardhan. He is a chartered accountant. He is a fellow member of the Institute of Chartered Accountants of India, and he is in this profession from the very beginning of the IBC era, that is 2017. He has handled more than 50 cases in person with his name, and also another 150 assignment as an advisor, managing a total debt resolution portfolio exceeding to 25,000 crores. And he is a chartered accountant, and he is a partner in Panitkar and Patwardhan. He is also associated with Sumedha Management Solutions Private Limited, an insolvency professional entity. Also with via Jure Advisors Private Limited advisory firm. Comes from Pune, and he is a rank holder for the commerce from Pune University. He is also a MBA rank holder. He is a law graduate also, and his areas of specialization are management consultancy, corporate advisory, financial and commercial advisory. His expertise extends to also strategic areas like corporate and expansion strategies, mergers and acquisitions, succession planning, providing insights into commercial litigation and arbitration. His accomplishments include uh, his recognition as a master trainer for IBC by World Bank. Also, he keeps on addressing gatherings like at IBBI, IPS, and other banking forums. He is a master trainer for IBC code, and he is also trained for IBC code master training for training. So I would like to invite Shri Udayraj Patwardhan sir to share his insights on the today's topic, creditor initiated insolvency resolution process.
So shall I?
Patwardhan, sir?
And we are going to work on this with Namrata leading the whole session. Namrata has been working in IBC with our own chartered accountant and member, Mr. Ravindra Chaturvedi, who has now been elevated to principal bench in New Delhi. And Namrata has been working with him since long with the institution and has handled multiple cases. So Namrata, being the anchor of the whole process, has somehow skipped introducing herself, but I will take this little opportunity to give little of her. So she's everywhere in IPNet that we do, right from designing the MOMs to prepping people, coordinating and everything. as well as she is doing excellent academically as well as in IP business also. So with this little background, Namrata, we can start now. If anybody has any question, I would ask them to raise hands and not to speak out in between, but raise hands. We will come back to you. You can also type the questions in the chat box also, because the way these sections are designed, we get answers from many queries as we go through the section. So maybe your query will be addressed during the course of the discussion from section 58A to section 58K. I'm hoping that. So let us proceed on these lines. We have hardly 1.5 hours to cover this, and we have about 30 slides to cover that. So with that, let us proceed. Thank you.
Yes, sir. The introduction, I'm humbled, sir, and very, very humble. This is my first session as well to be taken, and it's an honor to be doing it with you, Udarat sir, and Ashish sir. Thank you so much for the opportunity. I mean, it's really a humbling day for me. And sir, we introduced the topic CIIRP. Udarat sir, should I just read on this?
Let me take the first slide.
Yes.
So PIIRP is the word that we will be hearing a lot of some time. As Makijaji said, unless the issues are tackled, we may not hear this word after long, which happened with pre-pack insolvency. That same fate may be there for this if appropriate care is not taken while implementation. But I don't want to be too apprehensive about it. We will be very positive when we discuss this. So this is a new structured and time-bound framework where creditor can initiate insolvency more quickly or more efficiently. So the starting of the insolvency process is going to be easy. And they say that creditor's right will be safeguarded. So debtor will be, though they are avoiding to use the word, but let me tell you that it will really be debtor in control. As Ashish ji has pointed out, the debtor will be in control with RP having supervisory rights. However, debtor will be doing almost all the decisions, and RP will have a right to do a veto for any decisions that are being taken. So we will discuss how it will happen. So the best practices are yet to be designed, best practices are yet to be derived at. And as communities like us keep on discussing these issues, I am hopeful that when the regulations would come in and we actually start going into this process with the help of the creditors and the debtors, we might be able to design some kind of process which has best of both debtor in possession and creditor in possession model, and may be able to find some way in. So with this brief background, let us understand section by section, clause by clause, as to what is expected of this process. Over to you, Namrata. We can start.
Yes, sir. So we start with section 58A, which is the corporate debtors eligibility insolvency resolution process. Section 58A1 is the eligible corporate debtors. So here we are going to talk about a creditor initiated insolvency resolution process, may be initiated under this chapter for following corporate debtors, whether the CD is assets or income of both below notified levels, the CD with specified class of creditors or debt amount, and such other categories as may be notified by the central government. So, sir. Yes.
Not being made applicable to all the corporates out there. So we are expecting that it will be applicable to smaller companies, maybe MSMEs and little larger companies. We don't have an idea about what the size could be. So they will decide about the asset size or income size or both. Now, which income will be considered? The income as on the year end, say last financial year end, or how, that is yet to be seen. And when we talk about asset size, do we look at the balance sheet asset size or the valuation? That also is not yet known. So those two questions remain unanswered. And second most important thing is it should have a particular class of creditors. and a particular amount of debt also. So when we are looking at the corporate debtor with a particular asset size and income size, that is the income of the CD as well as assets of the CD, simultaneously, there would be qualifications as to which type of creditors will be able to do it. I am expecting that they would say that RBI controlled entities, that is bankers, ARCs, NBFCs, etc., might be eligible creditors to initiate this process. That is what we are expecting. And individual unsecured related parties, etc., might be excluded. That is what we are expecting at this stage. The regulations will state how it is going to be. And then they would say that the category also can be specified irrespective of the asset size and income size. So that all is just to be specified, but I have just tried to give my perception as to how it is likely to be, as to who will be able to participate in creditor initiated insolvency resolution process. I am saying participate because creditor will also participate and debtor will also participate. Before I proceed, I will also say one thing, that there will be required to be certain kind of trust factor between the creditor and the debtor, because it is going to be debtor in control. So in case of some assets in which the creditor does not have enough trust on the debtor, they may not go to CIIRP. They will go directly to CIRP. So there are many other things which come to our mind, and we will discuss as we go through it. But you can also start marking those things as to who could be the likely contenders, corporate debtors who will be taken into this process. And there could be some exclusions also. Yes, Namrata, we can go ahead.
Yes, so we talk about 58A2, which is ineligible CDs. A credit initiated resolution process cannot be initiated if an insolvency resolution or liquidation proceeding is already commenced and still ongoing under Part 2 of the IBC. The CD has already undergone creditor-initiated insolvency, pre-packed insolvency, or completed a corporate insolvency resolution process within a preceding 3 years of the proposed commencement date.
So what we are trying to take down if a corporate debtor, that is the company under an LLP, is already undergoing CIRP, it cannot shift itself from CIRP to CIIRP. So once a CIRP has been initiated, there is no backtracking possible into CIIRP. That is not possible. Additionally, if the corporate debtor has already undergone, of course, successfully, this type of insolvency, that is CIIRP in the past, or a pre-packaged insolvency, or a CIRP has been successfully completed, that has happened in last 3 years, then it is not possible to initiate CIIRP again. So this is another check, that in which cases the process cannot be started. So first was the eligibility, 58A1, and 58A2 is a blanket disapproval of cases where this process cannot start. So with that, now we can go to 58B now.
So we finished 58A, eligible and ineligible CDs. 58B, initiation of creditor-initiated insolvency resolution process. So we start with the role of financial creditors. Eligible financial creditors are defined. A financial creditor from notified classes of financial institutions may initiate the process when the corporate debtor defaults. The key steps, including here, are RP appointed by the initiating creditor, and process must follow prescribed conditions and procedures. Yes, sir.
So just look at 58B1 first. What they are saying is the
धीरज जी आपका आवाज कट रहा है.
am I audible to all, or
Yes.
I am facing
Initially, then
no.
initially it is cracking, then
Yes,
later
yes.
it is stabilizing.
Okay, I will speak slowly because I have some issue with my laptop. Actually, I am using my office laptop, and there might be some issue. I am extremely sorry for that.
Now it is okay.
Okay, so the financial creditor will be from a particular class. So as I said, I am expecting it to be RBI regulated entities, but that is completely my apprehension or my expectation. So only that creditor will be able to initiate the process. Nobody else will be able to do it. And when that process is being done or initiated, then that will be done by appointing a resolution professional according to what is given hereafter. So 58B says that only those creditors will be able to do which are notified by central governments. You are expecting a notification for that. And they say that it is done by appointing an RP according to provisions of this section. So which are these provisions? We will see that in 58B2. Let us proceed to 58B2.
Yes, sir. 58B2, all about approvals and intimations. 2A and B is initiating the process, the approval requirement. The final FC must obtain approval from notified class of FCs representing at least 51% of value of the debt. An intimation, CD must be informed on the intention to initiate insolvency. Debtor is given a minimum 30-day period to make representation or respond to this.
Yes. The first question that came to Dr. Makhija's mind is answered here partly as to how to obtain this 51% if there are related parties, some other creditors, etc. So if we read 58B2A, it tells us that the FC who is seeking to initiate the process shall obtain approval of FCs of the CD. But which type of FCs? FCs which belong to the specific class of institutions that are notified in the subsection 1. So in subsection 1, we saw that only a particular class of institution will be able to do it. Now, even the 51% has to be sought from those institutions which qualify as FC who can initiate the process. So let us take an hypothetical example that a CD has 3 creditors. One is a nationalized bank, one is an NBFC, and third is a related party, unsecured creditor, all having 30%, 30%, and 40% of the credit. So in this case, A and B. So A and B, that is the nationalized bank and NBFC together will make 60% of the total financial creditors. But in this particular case, that related party of 40% will be completely ignored. So what we will have to do is that 60% will be 100% for the purpose of calculating the number. So if this 30% and 30% both agree, they are enough because both will contribute to 100%. So they will be able to do it, and related party will not be able to put any hindrance or spook into this. Even if that related party is 50% and others are 50%, still it will not make a difference, because while calculating this 51%, we will be ignoring those unsecured loans from related parties while calculating 51%. So that is some kind of a check or carve out which has already been built in this process in 58B2A, that is seeking approval of 51%. Is 51B also covered here? Yes, B is also covered here in this slide. So 58B2 is informing the intention to initiate the process to the CD. So when this 51% is obtained by the financial creditor who is in a particular class, so a new class will be created as we have seen. That creditor, after seeking 51% approval, will write to the CD that we intend to initiate CIIRP in the case of your corporate, and a time of at least 30 days, means not less than 30 days, 30 days or more, will be given to the CD to make any representation and that representation will be in the form and manner which will be specified. So there will be a specific form in which representation shall be made. Please understand, the word used is representation, not objection. So they cannot technically object at this stage. They will have to make a representation to the FC in that class who has intimated that we want to initiate the process, and that representation will be considered by that creditor. Let us go to the next slide.
Yes, sir. So we come to post-representation actions. 58B2C. Final approval and continuation. Your consideration period is the creditor's review debtor's response, if any. Then there's a second approval if pursuing initiation post-response must re-obtain 51% approval within the next 30 days. If there is no response of CD, then debtor does not respond, creditor may proceed after expiry of 30 days. And a fresh approval path, here we would like to say if approval not received in time, fresh approval is required as per step. Yes, sir. So there are multiple steps involved here. I believe we take it in parts.
Let me try to explain.
Yes.
So we will go to 58B to C now. So the notice has been given, 30 days notice or intimation. They are using the word intimation, not notice. So intimation has been given that we wish to start the process, and you are given time of say 30 days to give representation. Now there will be two scenarios. Representation has been given or it has not been given. So the CD gives a representation or CD does not give a representation. Let us see as to what happens in these two cases. So if the representation is received, then where the FC is satisfied that, okay, we don't want to initiate the process, then the whole matter will be dropped. However, after the representation is received and FC decides that we wish to pursue the process, then that financial creditor will again go back to the class of creditors with that representation saying that, look, I took your permission, I gave the intimation, and now representation has come back, and this representation either agrees to it or doesn't agree to it or whatever. It may have, don't start it, I am doing this, I am doing that, and you don't have to do this process. Or it may say that, okay, come on, I am ready for this process and you can start the process. So they are not using the word of objection. They are saying representation. It could be positive representation. It can be negative representation, whatever. So in that case, whatever the case, the FC will again go back to the creditors and show them, this is my intimation, this is the representation, and again get 51% approval within the next 30 days, and then the process can start. So
sir, how this 51% will be calculated? How I will come to know how many creditors are there in the company as a FC?
As an FC,
on a particular date, how can I calculate on the basis of means who are the creditors, free creditors and all?
So those creditors and all that information will be required to be available with the creditor. So what you will do typically is you will go to the balance sheet of the company, you will know what the creditors are. So all that information will be required to be collected by the financial creditor. So how it will be collected, whether the party is cooperative or not, all that information and processes are not yet specified. So we are expecting that to be available to us and the creditors when the regulations come out. And as I said initially, if the trust factor is not there, then creditors may not proceed in this particular manner. So how to collect that information is very, very important, because in case where there is a funding done in a consortium banking, then maybe you know the consortium bankers. But in case of multiple banking, where multiple loans are obtained from multiple bankers, there are multiple securities. In such cases, as you have rightly pointed out, it will be difficult for the creditor to know as to which creditors fall in a particular class even if they fall in a particular class, whether they are related parties or not, this information absolutely is going to be a difficult task for the financial creditor to obtain. And how they will go beyond that obstacle is still not known to us. That only time will tell that to us.
That is what I just wanted to
Yes.
point
No,
out.
rightly pointed.
How can
Rightly
this
pointed.
be? Means how can I come to know how many creditors are there and not? And that
Yes.
then this representation, what you are saying, sir, is rightly that they have the right to represent, but do they have? Is there any blockade that they cannot go to NCLT once their representation is not accepted by the financial creditor? There is no such thing written, I think, that they cannot challenge their rejection of representation.
They can challenge that, but only after appointment of an RP. So we will address that. So this is a very limited scope available to the CD as to when it can object. Now it will be, of course, be taken to NCLT as to why they could not object at representation level and go to NCLT. That question still lies. So we will address that also simultaneously. So I will go to the next stage of obtaining 51%. So 51% approval has to be obtained on the representation from the creditors by the initiating FC. Now there could be a situation that 51% did not come in within 51%. So if doesn't happen that the creditors did not give 51% approval, then this process falls at this stage, and the financial creditor who is initiating will have to go back to 58B1 and start the process again. So it is not that on 35th day the approval is received and we will proceed. That is not possible. 30 days pass, the intimation given and the representation that is received, both will fall, they will be ineffective, and a new process will be required to be started. That is what is presently stated, that fresh approval under clause A, that is 58B2A, will be required. So you will go back to the creditors, again seek 51% approval for initiating the process, and then again representation, and so on and so forth. So it is for the creditor to say as to how many times it will be done, because there is nothing given here as to how many times the creditor will be able to do it. It looks like he can do it n number of times. So it is not that he can do it once or twice or thrice. That is not given here. So that is something which is very difficult to address.
Whatever process
yeah.
Yes, sir.
Whatever process we have discussed so far, is it considered as initiated, or only when it is filed in the NCLT, then only the initiation date will commence?
Yes, sir. I will address that. We will see that in a couple of slides as to when it is initiated. It is not yet initiated. It is only correspondence right now between the creditor and the debtor. So initiation has not been there yet.
So I'll just summarize if I'm correct. Just correct me if I'm wrong. The first 51% is sought. Response from the creditor. If it doesn't, if the CD, if it doesn't come in, then the process may start after 30 days. If a representation is received from the CD, then the applicant has to go back.
Not start after 30 days unless second approval from the creditor is received. Whether representation is there or not. To start the process with the representation or without the representation, second approval from 51% will still be required.
Perfect. Thank you, sir. I'll just go to the next slide. Which will be section 58B3. That is the conditions for appointment. Upon meeting all requirements under subsection 1 and 2, the FC may appoint an IP as the RP. The appointed RP must have no pending disciplinary proceedings. Appointment is to be made immediately after fulfilling all procedural steps, which ensures only eligible and compliant professionals manage the insolvency resolution process. So I guess this is a regular for all across all of IBC, right, sir?
It is all across there. If there is no disciplinary action pending, then only RP can be appointed. Absolutely correct. But this section is very important. Now, the representation has been received or not received, the creditors have given 51% approval to proceed with the process, and now the FC who seeks to initiate the process will now, it says may, means it is up to the discretion of the creditor whether he wants to proceed with the process or not. At this stage, that creditor may appoint. It is still the creditor who is appointing. It is not the 51% who is appointing. 51% is only giving consent to appoint, but it is not being appointed on behalf of those creditors. It is being appointed still by only the financial creditor who started the process. That creditor may appoint an IP as RP, and that is subject to there being no pending cases against the creditor. So that appointment will happen at this stage. Now, when will the consent be taken? Will it be taken at the time of getting initial consent, or at the time of sending the intimation? All that we will know when the regulations come out. What I am expecting, that it will be taken before they start the process. That is, when they want to send the intimation, they will take those approvals. That is what I am expecting, but it is not known to us yet. So with this, we have now come to a position where the FC has now the ability to appoint RP for the CIIRP. And when it is appointed, what will be done by the RP? We will address that in the next slide.
Yes, sir. So section 58B4, post-appointment obligations. First will be the public announcement. The RP shall make a public announcement for the initiation of the corporate creditor-initiated insolvency resolution process. Then the communication, the RP must submit a report to, now the NCLT comes in, a report to the NCLT and the IBBI confirming whether the financial creditor meets the requirements under sections 58A and 58B. The commencement date. The creditor-initiated insolvency resolution process is deemed to have commenced from the date of the public announcement.
So this is the initiation date, the date of public announcement. So this section appears to be very simple, but it raises a lot of questions in my mind. First, they say that the RP, as soon as it is appointed by the financial creditor who initiated the process under 58B2A. So the process is started now. The permissions have been taken. 51% initially, representation received or not received, 51% again taken, and the process is now going to start. The RP is appointed. As soon as RP is appointed, the appointment letter comes from the financial creditor. The duty of the RP will be to make a public announcement. In how many days? Not given here in the Act. I think it will be there in the regulations. So it will be published by the RP that CIIRP has started. So you can see that there is nothing like going to NCLT, taking any permissions, taking any approvals, COC not yet formed, nothing has been done till now. And the process has now started on the day of publication, that is the initiation date.
No IRP also.
There is no IRP also here. It is the RP.
There is no IRP. It's starting.
He is RP for CIIRP. He is RP for CIIRP. The concept of IRP may not be applicable for CIIRP as well as a converted CIIRP from CIIRP, because there is a provision that CIIRP will get converted into CIIRP. There also IRP will not be there. So IRP is completely excluded in this process. So please note that. So the appointment has been done, public announcement is made, and the process has initiated from the date of public announcement. How that public announcement will be made, newspapers, etc., etc. I am hoping that similar provisions will be applicable here. There are repetitive sections, that is, some sections from CIRP apply mutalis mutandis with modifications to this process. So those are the slides which are at the end. We will take it up in between also, because you will always ask a question, how that claims will be verified, how the COC will be formed, what are the duties of the RP, what about non-cooperation. So they have tried to address that, but that all appears at the end of the sections. So that is how it is. So we will address that when we reach there. So don't worry about it. So we will go accordingly. So the process has now started. Now comes the question about sending a report to AA. I am okay with sending the report to OA in whatever the format, but the report also wants the RP to confirm whether the FC meets the requirements of 58A and 58B. So whether the creditor is under the class or not, whether it is a related party or not, all those questions will be answered by the RP after he sits in the place and the process has started. Then the report will go. So this appears to me a little contradictory, that the process has started, and at that point, if the RP gives a report that the FC doesn't meet the criteria, then it will be an unnecessary effort and the CD will be unnecessarily put into the process when it shouldn't have been. So I think they will modify it appropriately, and the regulations may state that there will be two reports. One is when you are getting appointed, maybe you will be required to file some kind of report that I have been appointed and I am going to make a public announcement, everything is in order and I am proceeding, something like that. So I am expecting that. However, if that doesn't get I would say doesn't get appropriately adopted in the regulations, then this is going to be an issue of some responsibility on the RP, that even if not specified, when he is being appointed, I would say that you go and you check whether the FC who is appointing you is really qualified or not. Go and see whether the 51% is really the correct 51% or not. This is the question asked by Manoj ji as to how they will know 51%. So maybe RP will have to go and do all these things and see that whether the specific qualified creditors are there, whether anybody is excluded, whether the 51% correctly counted or not. I think RP will have to do it, double check it before he actually makes the public announcement, whether it is provided so in the law or not. So this is the way the process will be commenced. That is, we were at 58B3 and 58B4. So we have covered up to that, and now we will go to 58B5.
So just one comment here, like Afi sir said, as yet moratorium is nowhere in the picture. It is still to come. Picture baki hai.
There is no moratorium yet, and the way moratorium will kick in is also very unique way of kicking moratorium. So whenever the RP wants, RP can start the moratorium by making an application. We will see how it happens.
Yes. So we come to section 58B, subclass 5, exclusivity during CIIRP. That is suspension of other insolvency applications. During the creditor-initiated insolvency resolution period, no application for CIRP under section 7, 9, and 10, pre-packed insolvency resolution process under 54C shall be filed or admitted against the same CD. This
is a very unique section, that CIRP cannot be started when CIIRP has started. Now I will tell you, there could be some misuse also of this provision. For example, if it is dominated by some unrelated but friendly creditors of the CD, they may start the CIIRP for some period and the CIRP can be prolonged. That is always a possibility. So we have to be a little wary about these provisions. So new CIRP cannot be started either by FC or by an OC or by the CD itself. Not possible. And second is very important. No prepackaged insolvency resolution process shall be filed or admitted. So if it is filed, even admission is also not possible. So pre-packaged insolvency resolution process is completely kept out. If it is filed, it cannot be admitted also. So these two provisions are there, and it is now exclusive that when this process starts, this process will be exclusively proceeding without any hindrance, without any CIIR, without any CIRP, or pre-pack insolvency coming in the process. So with this, now we have completed this section 58B, and we go to 58C about objections.
Just the last slide, sir. Few key definitions under 58B before we come to 58C. So key definitions of CIIRP is creditor initiated insolvency commencement date, the date on which the public announcement of initiation of CIIRP is made by the RP under section 58B subclause 4. CIIRP process period, the period starting from commencement date and ending on the date when the NCLT passes an order under, one second, I'll just mute somebody. So here it ends when the NCLT passes an order under section 58H1, which we will be seeing in due course, 58I1, termination of process without resolution, and section 58J, read with section 31, that is the liquidation order. All these will be addressed in due course. So we'll come to section 58C. Yes, sir. Objections. Mr. Vijay, I guess, wants to say anything, or can I mute him? All right. We come to section 58C, objections to commencement of the process. Right to object by CD. Section 58C, subclause 1, objection to commencement. The CD has the right to file an application to the NCLT if it objects to the commencement of CIIRP under section 58B. The application must be filed within 30 days from the commencement date of CIIRP, submitted in the prescribed form and manner, and accompanied by a prescribed fee. Yes, sir.
The first time that some kind of objection can be filed. There was representation. Maybe it could contain objections, but still the process will continue. So even if there are objections written in the representation and they are considered by the creditor can still proceed. There has to be a date, there has to be a default. That is two mandatory things. Now, please understand that whether that process was rightly conducted or not, the responsibility falls on the shoulders of the RP, because RP is required to give a communication and the report to the AA that the creditor who initiated the process under 58A and 58B has rightly been started or rightly been resumed. So when the objection comes in, and if the RP has not taken enough care to see whether the process has correctly been started or not, RP may be held responsible for anything that he has ignored or has colluded with the FC. That is what it can be said at that point if the CD's objections are right. So the date and default and all those issues, CD will, the creditor will think what he wants to think. But whether that is right or wrong will have to be communicated by the RP to the NCLT, AA, and to the IBBI also. And that report will go first, and simultaneously this objection will come in. So RPs will have to be very careful while they are accepting these assignments, while they are verifying the date, while they are verifying the default, and going ahead and sitting in the chair of RP under CIIRP. With that background, let us look at 58C1. Now the CD has still objection. Now they will have not new objections. They have already made representation. It is not going to be a case that their objections are something new. The objection would have already been there in the representation. But now they will come in as a formal objection to the commencement of the process under 58B. It may file application within a period of 30 days from creditor initiated insolvency commencement date. So it can be appealed or it can be filed an objection after or within 30 days from the public announcement. So unless the process has initiated, they are not able to file objections with NCLT. So that is something which I am expecting will see a lot of litigation. Let us see how it goes, and it will be in the form and manner it will be specified. After the objection is filed, whether the process will be stayed or not stayed is yet to be seen. I am hoping that the process will not be stayed but continued, because it is still debtor in control. So debtor will still going to be in control. The RP has only specific duties and responsibilities which it will be conducting. So that is the argument from the government side. Let us hope if NCLTs will take it in the same way, that they will not stay the process but allow the process to continue and simultaneously hear the application under subsection 1. So when they are hearing the application under subsection 1, it is discussed in section 58C2 that we are covering in the next slide.
My understanding is this is a big conflict, because if I am owning a company, if somebody is taking me to this process, and if I do not have even the right to object, will that sustain the Constitution of India? I have the right to object at the first stage itself before public announcement, because public announcement will affect my goodwill. So if the goodwill of the company is affected because of going into this process, so I have every right to go to the court and stop it until if my points have some valid facts. So it will be heard. If NCLT doesn't heard it, then writ jurisdiction will take care of it.
So we will see how it goes. What they are trying to do now is they are going to limit the objection to only very limited points. Already the law is proposed to be amended even for section 7. If you see the provisions that are being made, now they are going to concentrate only on debt and default, nothing beyond that. They are trying to move to the data that is submitted by information utilities, and the reasons for default nobody is going into. That is how the law is being made now. So if that law doesn't get challenged, and if that law settles, then this objections issue, which they have tried to tone down in the way of representation, they may say that representation is same as objection. But let us see how it proceeds. As Manoj has rightly pointed out, it may see its own share of litigation before these particular provisions settle themselves. So we are expecting that somebody who will be hit by CIRP will either go, or somebody who is apprehensive about the provisions may file a writ or a PIL, as the case may be. So let us see which objections can be raised and how those objections can be tackled by NCLT. Namrata.
Yes, sir.
Yeah.
Section 58C, subclause 2 is the outcomes of the objection application. Is satisfied that no default and initiation contravenes section 58A or 58B, the NCLT may declare the CIIRP void ab initio, that is from the beginning itself. That is, if a default has occurred but initiation was in contravention of section 58A or B, the AA convert the CIIRP to a CIRP and pass orders as per section 58H subclause 1.
Let us see. C2 discusses what happens when such an objection is raised. So when objection is raised, there will either be a default or there will not be a default. First, if there is no default, then the matter is simple, that it will be out of the clutches of the process. But simultaneously, always remember, there is an FC who is initiating the process. There is an RP who is giving a report that 58A and 58B has been duly complied with. So the RP will be under scanner, 100%. So if there is any mistake on the behalf of RP, then the report has been given to NCLT and to IBBI, then it is going to be a challenge for the RP to reply to this process. Now, whether RPs are legally equipped to be able to give a reasoned report as if the default has occurred or not, whether it qualifies under 58A or 58B or not, is going to be a very challenging process, believe me. And it is going to be a process that RPs will be worried about so far as accepting the assignment is concerned. Having said that, I am hoping that it will be made simple, it will be made easy, and nobody will be a scapegoat in the process. I am just believing that And with that belief, if the default has occurred, or if default has occurred but they are not qualified under 58A and 58B, in that case the process will be void ab initio. But what about the loss of goodwill? As Manoj has said, what about any losses that the party might have incurred? There is no answer to that. So that remains unanswered. Now we go to the next eventuality. That default has occurred. There is debt. There is, let me complete this. There is debt and there is default. However, the creditor initiated insolvency process was in contravention with 58A and 58B. So default is there, but 58A or 58B has been contravened. Then it shall not make this process void ab initio. In that case, the NCLT will convert the CIRP into CIRP. So this is very unique case, that when the default is there and there is contravention of 58A or 58B, so wrongly it has been initiated, but default is still there, but the class of creditor is different, 51% not taken properly, so contravention of 58 and 58B, gross contravention of 58 and 58B, but default is there. In that case, the insolvency doesn't stop. It just gets converted from CIIRP into CIRP. So if the CD is a defaulter and objects that the people who started the process against me are not qualified, 51% not properly obtained, notice not given to me, intimation not given to me properly, violation of 58 and 58B, but default is there. So the objection is valid only technically. In that case, it will be converted into CIRP. This is a very unique provision made in this subsection. Yes, there was some question here.
So there are few questions in the chat box.
Yeah, the question over here, Udayji, is regarding that when we are saying when the no default has occurred or when the default has been occurred, but initiation is not covered under 58A and B, then it's a direct contravention. CIRP will be void ab initio, and the RP will go behind the IBBI regulations or the punishment.
Yes, so you're right, pointing out, sir. So we are talking about a situation where there is no default, but process followed under 58 and 58B is correct. Or there is no default and 58 and 58B also is wrongly initiated. So in case of no default, there are two situations. After there is no default, still you have started the process. But the process, the permissions taken from the creditor, etc. is correct. In that case, it is void ab initio because there was no default at all. But if there is default, whether the process is correctly followed or not, either you will continue with CIIRP, or if the process is not correctly followed, then you will be falling into CIRP. So there is no way out if there is default. If there is default, process correctly followed, CIIRP continues.
Now,
There is
the
default.
question is
It's
whether
not
the
correctly
RP can do the judicial role of deciding the default.
No, RP cannot do it, but still he will give the report. And if he gives the wrong report, then the result, you know what it is.
Got it.
Uday sir, there is one more possibility that like the process is initiated with 51%, report is given by RP, and then promoter is also not objecting to it. And during the claims received, if the total of the claim, then he finds that the 51% people have not started it.
If that happens, it will be the, according to me, there is no solution given in the law itself, but according to me, then it will be the duty of the RP to point this out immediately to the attention of the NCLT, stating that the claims that should have been in the balance sheet are not there, But now I have received the claims and it's seen that 51% is not really 51%, but it is only 22% or 30%, and appropriate procedures have not been complied with under 58A or 58B. In that case, the cognizance will be taken by NCLT and the process is likely to be converted from CIIRP to CIRP.
Yes, right.
Or the NCLT may say that since it is not followed, the process may be void ab initio.
No, so that is not possible, because if the default exists, there is no going back.
Okay.
Void ab initio only in case there is no default. But if default exists, there are only two ways: either continue with CIIRP or get it converted into CIRP. If default is there, there is no going back.
Next slide, sir.
Let us proceed. Let us proceed.
So we come to section 58C subclause 3, which is the timeline for AA. I think this clause is all over the amendment bill. If you see it, it's just everywhere. Now we come to decision deadline. The NCLT must pass an order on the application filed by the CD debtor within 30 days from the date of receipt of the application. If the NCLT fails to pass an order within this period, it is required to record the reasons for delay in writing. Odessa, this is all over the amendment bill. I really
yes. Yeah, this is everywhere that AA is expected to pass the orders in this prescribed period. Maybe in case of admission 14 days, or here it is 30 days from the receipt of the application. But if it doesn't happen, then the AA is required to record the reasons for the delay. The only apprehension I will always have is what if the objections are absolutely correct? Then what happens? The process should either be terminated ab initio if there is no default, and if there is default and the objections are right that 58A and 58B is not followed, then it has to be converted into CIRP at the right time, because in that case the board should not continue and it should be suspended and it should convert into CIRP. But that is also not happening, and there is third possibility of honorable AA giving a stay to proceeding with the matter, and then how many days it will take to pass through this process. So that is something which comes to my mind as to how to do that, because if they are able to record the reasons that they fear that party A needs to be heard, party B needs to be heard, party C needs to be heard, and in that case if it gets delayed beyond the point, then what to do about it? I don't see a solution there. So with that, let us proceed to 58D now.
Yes, we completed 58C. We come to section 58D, period for completion of CIIRP. The timeline for completion and extension of CIIRP, like we've already discussed, the CIIRP shall be completed within 150 days from the commencement date, which is the date of public announcement. And the extension, the NCLT may grant a single extension of 45 days if requested by RP, with approved by COC with at least 66% voting share, and no resolution plan. If no resolution plan is approved within the period, including extension, the NCLT shall pass an order under section 58H subclause 1, rejection of the resolution plan. Yes, sir.
Yes. So it's a very simple process of 150 days plus 45 days one-time extension. We are expecting that they really stick to this time period, because if there is no success in this particular period, there is a conversion into CIRP. So there is no end here. If this process doesn't succeed, then they will be going into the resolution process. But I am expecting that some kind of exception could be there. Plan voting is going on. Some issues came up. Some judicial matters going on. So the way CIRP has been extended previously from 180 days to 270 days to 330 days officially, and some of the matters, like one matter I am running as an replaced RP, the process is running till 2019, and I have been appointed as the RP of the renewed process in 2025. After 6 years, I am running the process again. I was given 150 days and I have already gone to 200 days, and I am still getting some more time. However, we are in the voting stage, etc. That is fine, and that is appreciated also well. that there is no likelihood of liquidation. That is not the option we want to resolve. But having that in mind, whether the same logic will be applied to the CIRP as well. If that is done, then unlimited extensions could be there, and there is a possibility of CIRP getting extended further. But nothing more to comment. This is only apprehension. Let us hope that it all happens in time. And let us proceed to 58E now. The duties and powers of the RP.
Duties and powers of the RP. In subclause 1, key responsibilities: call for submission of claims from creditors, prepare the IM detailing the debtor's financial status, and prepare a report confirming procedural compliance from the insolvency process and resolution plan adherence to Section 29A and Section 30 requirements. So
Yes,
basically,
so-
it's parallel, so what I believe.
So
Yes.
what is happening here is there are a couple of more sections which talk about which sections apply and which sections apply exclusively or with some modifications to this process. So first is calling for submission of claims. That is, with the public announcement, the claims will be called. That is what I'm expecting. But unfortunately, that particular section of public announcement doesn't talk about calling for claims as well. But in CIRP, if you see section 13 or section 15, they discuss about calling claims also in the public announcement. But that is not how it is worded here. So I'm expecting that we will be calling claims in the public announcement. Preparation of IM is also required. Then the issues of how the IM will be made, which regulations will apply, that all we are expecting in the regulations to come in. There is a specific report that is required to be submitted. I am expecting multiple reports, one report at the beginning, one report somewhere in the mid, and one report at the time of submission of the resolution plan. So a report at the time of submission of the plan is very specifically written, and even at the time of objections there will be a report. So those two reports I'm expecting to be there, but some more reports also may be specified in the regulations. So this is required to be undertaken by the RP, and the RP is also required to see that provisions of section 30, 31, 32, 33, 34, 35, 36, that is the compliance of the plan with the regulations, the distribution pattern, how the plan will be put to voting under section 30 subsection 4, how the COC will approve the plan under section 30 subsection 6, all those will be applicable here. And of course 29A verification will be required to be done by the RP. So all that process will be applicable mutalis mutandis, by which we mean that it will be applicable exactly as it is with the modifications that are proposed here. So that will be applicable here again. Other than that, let us go to next slide.
The unit will be under the control of corporate debtor only.
Yes, the debtor will be controlling it. The board will continue. It is not suspended. They will continue to do their job. They do their duties, their directorial duties, their employee duties. They will do everything. Only one thing which we will be seeing it, the RP shall be attending all the meetings of the board, etc. We will see that soon. But for all practical purpose, it's the debtor in control.
Then what is the difference between PPIRP and CIRP?
That is,
Sir, sir,
Initiation
sir,
only the difference, it looks like.
Initiation is the major difference, yes.
Okay, thank you.
So we come to clause 2, section 58E1. Additional roles perform duties analogous to, like we discussed, section 18 clauses A to C and section 25 to clauses E to J. Exercise. Yes, sir.
Yes. So what happens here is when we are talking about the duties of the RP, section 18 A to C and section 25 to E to J, only those they have specified that will be applicable here. We will take a minute to see what those sections cover. So let us go to section 18A to C first. So section 18 in the IBC code, I will go to the original code at present. I'm not referring to the modified code because the code also expects certain modifications in those sections also. So section 18A to C is duties of the IRP. Section 18A is about collecting information about the business operations for 2 years, operational payments, etc. for 2 years, list of assets and liabilities and other things. B talks about receiving and collating claims. So you will be calling claims as per the public announcement. They here say as per section 13 and 15. Now here we are not giving announcement as per section 13. We are giving announcement as per section the section in IBC in the section 58. So that will be little different. So we are expecting this to be ironed out. And most important, 18C. 18C is Constitution of Committee of Creditors. So these are the 3 subsections from collecting information, receiving claims, and Constitution of COC are made applicable here under section 18. Now we go to section 25. Section 25 is again an important section which covers the duties of the RP, and they are covering section 25 to E to Z. Now E to Z covers is updating the list of claims, convening the meetings of the COC, preparation of IM, inviting of the resolution plans, presenting the plans to the COC, filing avoidance application, and any other things that can be specified. So those things have been made applicable here. So when we are writing our own master chart as to how this process will run, we will have to create a new document, including those things here as to these are my duties in CIIRP. So we will come out with some kind of document at IPNet also, and we will circulate it for the benefit of the members. As soon as this law gets amended, it might be helpful for all. So this we are talking about section 18 and section 25, what is applicable. They also talk about applicability of section 19.2 and 19.3 as well. So you all aware that section 19.2 talks about if the personnel of the CD, the promoter and the contract people, as is the amendment now, they do not assist, then an application may be filed. So 19.2 application can be filed. And 19.3 also is applicable, that on receiving such application, AA may pass appropriate orders. So those are appropriately covered under this section 58E. So with that, now let us proceed to the next section, 58F.
Yes, sir. Management of affairs of the CD and cooperation of its personnel, as we already discussed. The management of CD during CIRP remains with the board of directors or partners during the CIRP period. Provisions of section 58H apply mutatis mutandis with necessary modification to these proceedings.
Yes. So the first and most important is the process continues, and it is very specifically stated in 58F that management of the affairs of the CD shall continue to vest in the BOD or partners of the CD as the case may be. And provisions of section 58H shall apply to the proceedings under this chapter. Now, section 58H, as you see, has been referred multiple times. Now, why are they referring to 58H multiple times? Is that when there is non-cooperation, they are providing for converting the CIRP into CIRP. There is a specific provision that if there is non-cooperation, the process will not continue. That is why the provisions come in, that you will be in control only till you cooperate. You will continue to control only till resolution doesn't happen. Or when the resolution happens, the control will be shifted to the successful resolution applicant. If there is liquidation, it will be liquidated, you will no longer be in control. So till CIRP continues, board will be in control. As soon as CIRP gets over, either by converting into CIRP or by approval of the plan or by approval of the order of liquidation, the board will lose its control. Either they will be suspended into CIRP or in liquidation, they will not exist. So these provisions apply. That is why there is a reference to 58H again and again, because section 58H talks about conversion of the CIRP into CIRP. We are going to see that section separately. Let us proceed.
Yes, sir. Now the interesting part, where if the management is with the current corporate debtor, where does the RP come in? Role and powers of RP and obligations of promoters. Section 58F 2 and 3. The RP has to attend meetings of members, BODs, partners, and committee of directors, and has the power to reject any resolution passed at these meetings, and such rejected resolutions cannot be approved. Promoters and personnel must provide relevant information to the RP timely and accurately for preparing the IM. Persons causing loss, damage through omission or false misleading information will face liabilities with sections 54G 2 to 4 and section 77A applying mutatis mutandis.
This is very interesting that the RP will have a right to attend the meeting of the BOD, has a right to attend the meeting of committee of directors. So even committee meetings the RP can attend. RP can attend the meetings of partners also, and he shall have right to reject any resolutions that are passed in the meeting. So his right is limited. I will put it in different words, that if there are any resolutions being put up, then the RP is able to stop those resolutions by using his veto if he rejects the resolution. How they will be rejected, why they will be rejected is not discussed here in the code. I hope that is discussed and some guidance is given to the RPs that how he will decide or she will decide as to when such resolution needs to be rejected. And otherwise RP will be again coming into line of fire as to his behavior, whether he should have rejected the resolution or not. It could be as simple as change of auditor. Whether that change of auditor should have been seen by the RP as acceptable or not acceptable. So every resolution that comes into the meeting of the members, either in the committee meetings or of the meetings of the directors or partners, RP will be under scanner as to what decision he took, whether he agreed to it or did not agree to it. First. Second, there is always an apprehension that in case where the corporate debtor is not following a very transparent way of running the factory or running the business or running the organization, then they may avoid taking some resolutions in place if they have very wide powers already given to the CEO of the company. It happens that there are certain resolutions which are already passed. They are not going to be revisited by the RP. That is not expected. So if there are unlimited powers already given to the directors or to the board or by the board to the CEO or the CFO, then what is the recourse? Then the RP's duties will be compromised to that extent. So RP again will be under scanner as to what he did on that particular thing, and that will be an issue. And in subsection 3, what is the issue is the promoters, personnel, and the people who are in contract with the CD shall provide information to the RP for preparing the IM. Now the IM subsection has already been covered in section 18 and as well as section 25. So when that is already covered, there was no need to repeat it here, but that has been done. However, if wrong information is received and if loss has occurred, then those people who gave you wrong information can be taken to task under section 58G as well as penal provisions of section 77A. Now, in this case, provisions of section 58G are very critical. I am not going to repeat it here because the next section we are considering it 58G only. So let us go to section 58G.
Very interesting provisions of 58G, moratorium. Public announcement of moratorium by RP. The three requirements are: must make public announcement of filing of an application for moratorium under CIIRP, and order of the AA rejecting such application, if any. Announcement to be made in such form and manner specified and to ensure transparency. That is a regular.
Let us cover the next one also and we will come back. If I don't remember whether I had made 2 slides here or not. No. Okay, let us go back. Section 58G. So 58G is a very unique section. So during the CIIRP process, the RP may, after obtaining approval of the COC, so you have seen that section 18 applies. So you have already constituted the COC. You have received the claims and you have constituted the COC also. Now, with the approval of the COC, they are not saying as to 66% or 51%. So I am assuming 51%. Make an application to AA for moratorium for the purpose of this subsection read with 14.3. So moratorium shall apply when such an application is made. So that application can be made under 58G, and the proviso says that provided that the RP may file the application before constitution of COC also, after obtaining approval of the SCs, approval of the FCs in the class of more than 51%. So there are two situations: after constitution of COC or before constitution of COC. So after constitution, again with 51%, application can be made for moratorium. Before formation of COC, that is within the first 30 days when we hold a meeting of the COC, etc. Within that 30 days, if you need to apply for the moratorium, then in that case, 51% of the financial creditors in that particular class will have to agree. When this application is made for moratorium, this is a very unique provision, section 58G2. When the application has been made under subsection 1 above, the moratorium shall commence on the day of application. Please understand, the moratorium will apply from the day of application itself, not after approval by AA, and continue to be in operation during the CIRP process period, and the AA may confirm the moratorium if it is satisfied that the moratorium is required for proper and efficient conduct of the process, or reject application. So the moratorium will kind of be initiated by the RP making an application itself. As soon as the application is made, moratorium starts. And that moratorium is kind of started by the RP himself or herself. And that moratorium will be confirmed, is the word used here, by the AA, or may not be confirmed by the AA. So when such application is made, another public announcement is required to be made by the RP that moratorium has now started because I have filed an application under 58G1. The form will be given by the IBBI in its regulations. They will come. And when the moratorium is rejected by AA, then another public announcement will be made that the moratorium is no longer applicable now because my application has been rejected. So this is a very unique provision, 58G, and moratorium starts immediately on making application. So it is not difficult to start the moratorium. So this was the question that Dr. Makija had raised, that it may take time, etc. It will not take time. So that is very, very, very quick resumption of section 14 is possible in this particular case. So why this has not been provided as a mandatory provision, that we don't understand. I think this is to bypass going to NCLT initially, because moratorium could be applicable otherwise only when there is an order by a court. Here there is no order by a court. RP makes an application and moratorium starts. So this is a kind of a roundabout for that provision. I don't know how much it will stand the scrutiny of the law. Let us see how it proceeds. Let us go to section 58H now. We have only 15 minutes left. Let me complete the provisions up to 58A quickly, and then if I have time, then we will consider any queries. 58H.
Yes, sir. H is subclause 1A to C is that AA shall pass an order if no resolution plan is received within stipulated time, CD or personnel fail to cooperate with RP, and the resolution plan is rejected under section 58J2, read with section 31.2, then CIIRP converts to CIRP in these provisions.
Okay, so 58H title of the section is conversion of CIIRP into CIRP. So whatever I am talking now is when the conversion happens. There are three situations. One, resolution plan is not received at all within that 150 plus 45 days, not received. Or the AA is satisfied that there is no cooperation. So you file a 19(2) application and the AA makes an order under 19.3 that the cooperation is not there, or the plan is received but the resolution plan is not approved and it is rejected by the AA, for whatever reasons, including non-compliance with the code and the regulations thereunder. So if the plan is rejected, no plan is received, of which there is an order of non-cooperation under 19.3, then in such case, the AA shall mandatorily convert the CIIRP into CIRP, and accordingly chapter 2 will start applying. However, the interesting provision here is the stage of CIRP shall be decided by the AA, and that will be decided on recommendation of committee of creditors. So maybe they will resume the process on, say, reissue of Form G, and the process will be again continued. So it doesn't start from public announcement and then filing of claims and again forming of COC. All that can be excluded, and the process will start from a particular stage. I am expecting from Form G onwards. So again, the second apprehension that was raised by Dr. Makhija is kind of addressed here, that it is not endless thing that will happen. It will only be one more opportunity to run the CIRP now with RP in control. Previously, it was the debtor in control. Now the process will be rerun from, say, hypothetically from Form G onwards with the RP and the creditors in control. Then simultaneously, it will appoint the RP also, RP of the CIIRP as the IRP or the RP for the process. So there is a provision here that it may be appointed as IRP as well, but I am not expecting that the process will start from day 0. I am expecting that the process will start from a particular stage, typically from Form G onwards. Then simultaneously, Section 14 moratorium will be declared, and it will also be declared that whatever are the costs incurred during this process will be CIRP costs. So the report of the RP in CIIRP will also include the CIRP costs. So that will be considered, and it will be stated that they will be CIRP costs. Now, where committee of creditors decides to do otherwise, let us go to the next slide. Yes.
Yes, sir. So where now the committee of creditors conversion by from CIIRP to CIRP, 58H subclause 2, COC with at least 66% voting share can resolve at any time during the CIIRP period to convert the process to CIRP. The RP must make an application to NCLT for such conversion, and the NCLT will pass an order as per the relevant subclauses 58H1.
Expecting that it will be smooth and quick, because the process is being run, resolutions plans are being received or not received. Maybe initially the creditor had a trust in the debtor that they will run the process properly, they will cooperate, etc., etc. On the face of it, NCLT gives an order that cooperate, 19.3 order. However, actually they are not cooperating, and time is getting lost, period is getting lost, money is getting lost, costs are increasing. In such case, COC may suddenly decide by way of a resolution that let us stop this process of debtor in control. Now let us move to creditor in control and let us start the CIRP process. Then at any stage, they can decide to convert this into CIRP with 66% vote. Application will be filed by the RP with the AA in the specified form to convert this CIIRP into CIRP, and the process shall continue as per recommendations of the COC from a particular stage onwards. Let us go to the next section. 58 H
subclause 3. Effects of conversion to CIRP. The avoidance transaction of fraudulent trading proceedings initiated during CIIRP continued during CIRP. Conversion orders deemed as an admission order under Section 7 of CIRP. FC who initiated CIIRP is treated as applicant for CIRP purposes. For insolvency provisions referencing initiation date, the CIRP commencement date will apply until CIRP commencement. So these are the effects of conversions. So,
application, etc. Wrongful trading, that is avoidance transactions or wrongful trading, 43, 45, 49, 50, or 66. So those or any proceedings started under section 47 in CIRP shall continue. They will not be having any break in between. Additionally, it will be treated as conversion into section 7 application because the original process was started by an FC. So it will be deemed to be a process under section 7. And accordingly, the applicant who initiated the process CIRP will be applicant for all practical purpose. And for the purpose of those avoidance as well as the fraudulent transactions, the initiation date, references to initiation date and ending on insolvency commencement date, the reference is there, will be construed at CIRP commencement date and ending on insolvency commencement date. So these changes will be there and accordingly it will proceed. Let us go to the next section 58I.
That withdrawal of public announcement made under section 58B. Here we come to withdrawal section of CIIRP 58I subclause 1 and 2. NCLT may allow withdrawal of the public announcement and close the process on application by RP with approval of 90% voting share of COC. Here there are two conditions: withdrawal not allowed before constitution of COC and after the first invitation for submission of resolution plan has been issued. So only period between that withdrawal is applicable, else it cannot be done. Yes, sir.
So it's a very fair and simple provision because as we have seen, even TVLA is being proposed to be amended. So accordingly, this process withdrawal also has been made very strict. And as per section 58I 1 and 2, it is very specific that the withdrawal is possible only when there is an approval of 90% voting share of the COC. So withdrawal is not allowed before constitution of COC. So 51% of the creditors in that particular class agreed to resume the process. The process resumed, public announcement is made, claims are received, COC is formed, and only thereafter withdrawal is possible. So withdrawal without COC approval is not possible. COC of 90% will have to agree. Further, before issuing the first invitation, I am considering it will be form G only or some other form which is specified. So before that is invited, before that, so only in that particular window, such withdrawal will be possible. Otherwise, CIIRP cannot be withdrawn by way of settlement between the parties, etc. So that is very important provision which is being proposed. Let us go to 58J now.
Yeah, 58I3, sir. I'll just finish it patapat and go to the next one. Yes, because NCLT shall order on the withdrawal application within 40 days of receipt. If they do not pass within the period, they have to record reasons of delay in writing as already discussed.
Same.
Yes.
Okay.
We come to the next section, 58J. Yes, sir. Approval of resolution plan. Section 58J, submission and order. Resolution plan, if it is approved, the COC with at least 66% voting approves the resolution plan under section 30, and RP submits the approved plan to the AA along with a report on procedural compliance as per section 58E1C. And the NCLT's role, upon receipt, the AA shall pass order in accordance with section 31 to approve or reject the resolution plan. The provision of section 35 apply mutatis mutandis to this proceedings. Yes, sir.
Section 31 applies. The applicant will submit a resolution plan along with eligibility under 59A. That plan will be examined by the RP under section 30 subsection 2, and the compliant plans will be presented to the COC for its voting, etc. Then that will be done under section 30 subsection 3. The plan will be shall be presented to the COC. Under section 30 subsection 4, the resolution plan will be approved by the committee of creditors or maybe rejected by them. So when it is approved by the COC, it will have to be done with 66%. And of course, when sections 30 is applying in totality, the RA may attend the meeting of the COC when the plan is being considered, and the RP shall submit the resolution plan approved to the AA under section 30 subsection 6. After it is submitted, as you are all aware, it will be considered under section 31 for approval of the plan as provided in section 31. So those provisions of section 30 and section 31 will apply mutalis mutandis here for these proceedings as well, with the modifications that we have just seen. So we now go to the last section, 58K.
58K, application for provisions of chapters 2, 3, 6, and 7 to this chapter. 58K1, certain sections of the code, like we can see 21, 24, 25A, 26, 27, 28, 28A, 29, 32, 32A, 43 to 51, and chapters 6 and 7 of part 2 will apply to the CIIRP mutatis mutandis with the modifications such as CIRP construed as CIIRP, insolvency commencement date construed as CIIRP commencement date, references to resolution periods adapted to CIRP context. So,
sections and CHP sections are applicable, which are not applicable. Namrata, we have a summary of that and we can discuss. Yes, please go ahead.
yes, sir. 58.2, the CIIRP process must meet conditions and procedural requirements and will be specified. Ensures consistency and integration of CIIRP with the broader insolvency regulation framework, legal framework. Yes, sir.
Let us go back to the previous slide.
The previous slide.
So which sections are applicable and which are not applicable? So we have seen that section 18, some part is applicable. Section 19 we have seen is completely applicable. Section 20 of management of the operations as a going concern is not applicable here, because that management is the duty of the CD's board. They continue. So section 20 is not applicable to CIIRP. Then section 21 is applicable, that is committee of creditors, how the meetings are held, etc. After that, if you see section 22 regarding appointment of RP, again is not applicable. So when you appoint an RP here, we are not expecting it to be changed quickly. There is no provision for change of RP here. I don't know why it could have been modified there, but replacement of RP, section 22 is not section 22 is not applicable. Section 23 is also not applicable here. Directly section 24 will be applicable. That is how the meetings are held. So meeting of COC, section 24 will be applicable. Then duties of RP, we have seen that only some subsections are applicable. So we are not expecting of raising of interim finance, etc. is not applicable. Only 25 to E to J is applicable. So appointment of accountants, raising interim finance, representing the CD to third parties, custody, taking custody, etc. They are not applicable here because we are not taking the control of the assets of the CD. So those will not be applicable. However, the duties of AR will be applicable if there is an AR. So 25A will be applicable. Then section 26 is applicable, that is filing avoidance application. Section 27 of replacement of RP is applicable. Appointment of RP is not applicable. Then we go to section 28, approval of COC in certain actions. So section 28 is applicable. So this is very important. So what is happening here is the RP will be guided by these provisions. So for example, some new loan is being taken by the board. And if the new loan is being taken by the board, there will be resolution coming in the board. Now for that to be approved by the board, indirectly COC's approval will be needed because section 20 is applicable. So if interim finance is required or security interest is created as per 28(1)(a) or 28(1)(b), in that case COC approval will be necessary. That also is a prior approval. So that prior approval is taken by the RP. Then the board resolution for raising such money can be approved, otherwise not. So link section 28 actions with the provisions that RP can have a veto in the meeting of the committee. So that will have to be streamlined, and you will have to think about what actions I can object, for what actions I will have to take permission from the COC. So please remember that. Even a section like 28(1), say 1(f), related party transactions. Now the board is going to do related transactions day in, day out. But we as an RP will be required to keep a watch as to what is the resolution coming up, whether it involves anything which is prohibited by section 28, section 28. If it requires the referral of section 28, we will have to run to the COC, take prior approval, then only those activities will be done. So duty of RP to see to it that section 28 is properly followed is a big duty. So please remember that in your mind before you see. Your duties are not limited, they are even more dangerous, more precarious now. Then we go to section 28A, that is applicable. This is a new section which we had discussed, in which creditors' assets which are in its possession, the assets which are in possession of creditor which are not owned by the CD, that is third party assets, PGs, etc., can be included. So that section is now applicable. Section 29, you are aware, is preparation of IM, that is applicable. Then section 30, section 31 we have seen they are applicable. And then other sections like section 32, section 32A, and provisions of 43 to 51, as well as the chapter 6, 7 and part 2 are applicable. So the CIRP process, excluding the specific provisions of CIRP, everything will be applicable here. So we will try to make some guidebook merging these sections together, so that we will have a master code for CIRP. By including this section, some kind of text we will put together as soon as the bill is passed and regulations come in, and I hope that will be a good guide for us to follow. So with this, I am stopping dot at 6 o'clock. Namrata, I hope we could do it. I'm not really sure whether we did justice to the topic or not. We were also learning with you all only. So with that, I stop now. And
Sir, I'll just briefly go through the chat box questions. Or
yes, we will do that. We will do that.
How will the RP take control of the CD? CD may question the authority of the RP, like whether he was appointed by the AA.
Yes, so there is no control to be taken. You just go there and show your iCard if it is issued by IBBI, along with appointment by your financial creditor, and say that you are the person sent by the God and you are going to sit there. There will be resistance, yes, and it is going to be critical. But as I was discussing this point yesterday at the corporate enclave, wherein the CEO of the ARC Association, Mr. Harihara Mishra, this question was put to him as to how will you be making sure that the process goes on smoothly. Then he says that we will be doing this process generally in the cases where we have trust factor with the CD. So CD will be generally accepting this provision. Otherwise, we may not venture into this and make another chaos without any control with us. So only when we are having surety that we have control, then only we will proceed. That is what Mr. Mishra's answer was, which I agree with him, that if there is no trust, then how it is. So if the object RP should approach NCLT, yes, if there is non-cooperation, of course, section 19 application can be filed, and in such application is filed, you have seen that under section 58H, the CIRP will be converted into CIRP. So that is how it is. It will be done.
Yes, sir. A's role commences with filing of report by RP along with the application of FC and supporting documents, namely voting, etc.
These are comments by people.
Yes.
So does RP vouch for financial transactions during CD under control? So my answer is no. Even in CIRP, we have a limited responsibility. Under the CIRP, the RP is not expected to sign the balance sheet. You will be under pressure to do that. So unless there is a specific guidance from IBBI or from NCLTs, please keep away from vouching the financial transactions.
So there's one interesting question from Mr. Shekhar Singh Gupta. So there is no mandatory moratorium period as such, no freezing of dues. So if there is no freezing of dues, can there be claims raised by the claimants?
Yes, there is freezing of dues as an initiation date. The claims will be received as of initiation date. So the claims will technically be freezed on that date. But and it will be the same as CIRP. So I am not worried about the claims not getting freezed. There is no moratorium. That is, they may be able to initiate recovery action, but dues will still be frozen according to me on a particular date. They will not be continuous claims which change every day. So we expect that the claims will be frozen as of the initiation date. However, if there is an action of recovery or foreclosure under section 14, if the section 14 doesn't apply, then RP will really have to rush and file an application, and as soon as the application is filed, moratorium will start. So that is how it will be addressed.
Yes, all other are comments, I believe.
I think we have come to the end.
Yes.
Thank you everybody for listening patiently to such a topic, and I hope we have done justice. Now let us conclude the session now.
Yeah, Gauri, are you there?
Yes, I am here.
Yes, so please let's conclude. Do we have Suhasini ma'am? Suhasini ma'am?
Suhasini ma'am is not there.
Joined,
Actually, she told, yes.
Yeah, so please, we can announce for the next week it will be circulated in due course. The announcement next week is a physical seminar, our first physical seminar at Hyderabad, and the flyers will be circulated in due course. Yes, Gauri, please take it forward for the vote of thanks.
Yes. Yes. I am here to present the formal vote of thanks. So I am privileged today to extend the vote of thanks. I would like to express my sincere gratitude to IPNet for providing me with this opportunity. Today's event was much more than a webinar. It felt like a start of something truly significant, a movement that will shape our professional community in the years ahead. First and foremost, I extend my heartfelt thanks to our IPNet president who has given us our keynote address, and Uday Raj Patwardhan sir and Namrata Randeri ma'am. Your presence had added immense value to this occasion. Your insightful words and vision have inspired all of us to think bigger and strive for the excellence. Thank you for gracing us with your time and wisdom. I would also like to thank our president, Mr. Ashish Makhija. Ashish sir, your relentless dedication and visionary leadership continue to make IPNet platform of unparalleled importance. Your address today reaffirmed that we are on the right path under your stewardship. Your guidance gives us the confidence to reach new heights, and for that we are truly grateful. I would also like to extend my sincere appreciation to Transition and their technical support team. Your work tirelessly behind the scenes, ensuring that everything runs smoothly. Your hard work is the foundation of all our successful events like this one. Thank you for your unwavering support and flawless execution. Finally, to everyone who has participated today, your presence, enthusiasm, and active engagement have made this event truly remarkable. Together, we are building a community that will not only foster professional growth, but also drive innovation and collaboration in insolvency profession across India. Thank you once again to all those who contributed, participated, and supported this remarkable initiative. This one is only the beginning, and I look forward to what we can achieve together in the future. Thank you, everyone. Thank you all.
Thank you. Thank you. Thank you so much, Uday sir. Thank you.
Any presentation of any memento, because we are all part of the team, so that we are not doing today. And I must thank Gauri, who has done the session monitoring today. Thank you for all her efforts, and thank you Namrata for joining and changing sides from that side to this side. Thank you very much.